Hey there. Dr. Anmol Gupta is a resident physician at the University of Michigan. One day a week, he drives 30 miles north of Ann Arbor to a rural clinic. And for a lot of his patients there, that's the only doctor they can get to within an hour.
They have to travel the furthest. They're often the ones that are uninsured or on Medicaid. They often are coming and seeking care later than when you wish they had access to care.
So they're sicker. And the cost of prescription drugs comes up in like every single visit.
And I'm meeting patients who are just now being able to afford these medications, who maybe weren't able to 5, 10 years ago, who needed it then.
Take statins, those drugs that lower cholesterol. One of the most popular brand name versions, Crestor, finally went generic in 2016. But before that, a lot of patients like Dr. Gupta's simply couldn't afford it. So now he wants generic versions for today's expensive drugs to reach his patients as soon as possible.
We're trying to prevent long-term risk here. The faster we can start these medications, the better the outcomes and hopefully preventing devastating things like heart attacks and strokes.
Which is why what's about to happen at the Supreme Court matters so much to him and to millions of patients like his. This spring, actually this week, the court is hearing arguments in a case that could make it harder and slower for cheaper generic drugs to become available to patients. This is An Arm and a Leg, a show about why healthcare costs so freaking much and what we can maybe do about it. I'm Dan Weissman. I'm a reporter. I like a challenge. So the job we've chosen here is to take one of the most enraging, terrifying, depressing parts of American life and bring you something entertaining, empowering, and useful. And our show's senior producer, Emily Pizzacreta, flagged the Supreme Court case for us months ago. Emily, you've been reporting the heck out of this story ever since.
Dan, I talked with lawyers. I talked with doctors. I talked with one guy who's both a lawyer and a doctor. And the good news is you don't need to be any of those things to understand what's going on here.
Great. Take it away.
Let's start with the basics. When a drug company invents a new medicine, they get a patent. Basically, an exclusive right to sell it for about 20 years, sometimes a couple extra years. Exclusive, meaning no competition. And that's part of why brand name drugs cost so much. But when the patent expires, other companies can make a generic version of the exact same drug. And those generics usually sell for much cheaper. The legal rules of this brand versus generic deal got hashed out back in 1984 in a law called Hatch-Waxman. We talked all about that in our last episode. But don't worry if you missed it.
The Hatch-Waxman Act made this balance between giving protection to brand name manufacturers to innovate and create new drugs. But then once their patents expire, the idea is that we open it up for generic competition.
That's Professor Sean Tu. He teaches law at the University of Alabama. He also has a PhD in pharmacology and a history working in the biotech industry. Sean helped write a legal brief in this case on the side of the generic drug maker. He says this case is about that balance that Hatch-Waxman tried to create. Because drug companies don't just file one patent and leave it at that. They file like a whole stack of them, starting with a patent on the drug itself, the molecule, and then a second patent on how the drug is used. So when the first patent runs out, they might still have years of protection left on the second one. But it doesn't end there. They can also patent new uses of that drug.
So here's an example, and I'm just going to make one up. I have drug X that was first approved for diabetes. Let's say the patents expired the year 2000. And then later on, I get a patent for that same drug to treat cancer. But that patent doesn't expire until, let's say, 2020.
Hatch-Waxman's rules say generic drug makers don't have to wait until 2020 to sell a generic for treating diabetes. But they do have to be careful with their generic drug's label. In the world of Hatch-Waxman, the label is not just the white sticker on the orange bottle you get from the pharmacy. The label means all that folded up paperwork full of small type that comes with your prescription. It's full of technical information about the drug. So, if a generic drug maker sells a version of Sean Tu's made-up drug for diabetes, they have to make sure that the label doesn't mention that the drug can also treat cancer. In the industry, they call this a skinny label. And skinny labels are a big part of getting generic drugs to market and making them available quickly. The industry says 4 out of 10 generics get launched with a skinny label. So, skinny labels are the big legal idea at the heart of the Supreme Court case. Now let's talk about the specific drug in this legal tug-of-war. It's called Vascepa.
Science of prescription Vascepa, proven in multiple clinical trials. Vascepa, along with diet.
Vascepa is made by a company called Amarin, and it's their only product. It comes from fish oil, and it's been approved by the FDA for 2 different uses. Well, kind of different. First, in 2012, it was approved to treat a rare condition involving dangerously high levels of a certain kind of fat in the blood. A few years later, Vascepa got approved for another condition, one that affects a lot more people with only slightly too much of that fat in their blood.
Prescription power, proven to work. Now with a new indication. Ask your doctor about Vascepa.
That second approval meant a second patent for the second use. Meanwhile, the patent on the first use was set to expire. When that happened, a generic manufacturer called Hikma jumped at the chance to come to market with a cheaper generic version.
Quickly about Hikma Pharmaceuticals, London listed under the code HIK, but founded in Jordan.
In 2020, Hikma launched their generic with a skinny label on the packaging. They say that skinny label was carefully written, that it only described the unpatented original use, that they definitely left out any mention of the second use, the one that's still patented. But Amarin, the brand name manufacturer, didn't see it that way, and they sued them. Amarin's argument has 2 parts. First, they say Hikma's label, even though it left out the patented use, still referenced a study that was only conducted for that still patented use. Second, they say that in press releases, on their website, and on investor calls, Hikma described their product a little too broadly, including calling it, quote, the generic version of Vascepa. Amarin says, put those 2 things together, and Hikma was effectively encouraging doctors to prescribe it for the use that's still under patent. The legal term for this is inducing infringement. There's actually a pretty famous Supreme Court case about inducing infringement, at least maybe famous to legal nerds. It involved a file-sharing service called Grokster. The whole product was basically built to help people swap pirated music and movies. But instead of my entire high school graduating class getting sued for copyright infringement, Grokster did, for inducing it. Sean 2 says induced infringement means you didn't infringe the patent yourself, but you nudged someone else into doing it on purpose.
You have to have the intent to induce somebody to actually infringe the patent. By looking at the label, by looking at these fairly innocuous marketing statements, I don't think any of them induce a doctor to prescribe for the patented indication.
And here's the thing. Some of the people who agree with Sean 2, they aren't who you'd expect.
Yeah, Amarin would have you believe that doctors pay attention to investor relations calls and making their prescribing decisions.
Greg Chopsky is a patent attorney who works mostly for brand name drug companies. About a decade ago, he was part of a team that won a $2.15 billion settlement. It was one of the biggest brand versus generic lawsuits ever. So he's not exactly a cheerleader for generic drug makers. But, he says, until recently, a case like Amarin's wouldn't have legs. Except things took a big turn in 2021. That year, a big brand name drug company, GlaxoSmithKline, we'll call them GSK for short, they won $235 million in damages from a generic maker called Teva. The accusation? Induced infringement. And Greg Chopsky says GSK's victory really shook things up.
What it did was it made mundane market activities potential bases for infringement claims.
Mundane marketing activities like calling your drug the generic version of something, saying it's been rated equivalent by the FDA. Normal things generic companies say all the time. But now,
the focus on what's printed on the label and what's being said in the market, what your detailers are saying to physicians, what you're telling investors, a bigger scope of activities could be used to find infringement.
Teva appealed their case to the Supreme Court, but the court took a pass on hearing it. And Greg thinks the court taking up the Hikma versus Amarin case is a sign they regret that decision.
I think this is a little bit of buyer's remorse from the Supreme Court that they did not take the GSK case.
So, just how important is this case? And what could it mean for us? That's next. This episode of An Arm and a Leg is produced in partnership with KFF Health News. That's a nonprofit newsroom covering health issues in America. The folks at KFF Health News are amazing journalists. Their work wins all kinds of awards every year, and we're honored to work with them. How big of a deal is Hikma versus Amarin?
So it's a pretty big deal.
Sarah Koblitz is a lawyer whose firm works with both brand name and generic drug companies. She's been watching this case closely because however it goes, she says it changes how everybody in the industry operates. And Sarah says part of the reason it's a big deal is because of how early in the process this case is being heard. No jury has weighed in, there hasn't been any discovery, no documents have been exchanged, there haven't been any depositions. So the question before the court is, should this case get tossed out without even having a trial?
So it is deciding whether the case can continue and Amarin can continue to make those allegations against Hikma.
If it rules for Hikma, the generic company, the court could say, this kind of a case just shouldn't be a thing, claiming induced infringement over what experts like Sarah and Greg Chopsky say have been totally normal skinny label practices for decades. The court could say there's no there, and not just to Amarin.
Theoretically, other companies should be on notice that they can't bring induced infringement cases on such little evidence.
On the other hand, if the court rules against Hikma, that would be a big worry for every generic drug maker.
The idea that you can have a case go with very little evidence about what has been said to induce infringement will mean that it's really easy to bring litigation against these generic companies.
Easy to bring litigation that would cost those generic companies millions of dollars to fight. Big money. And that's just the cost if they win. If they lose,
the ramifications for being found guilty of induced infringement are really significant. It's treble damages, so it's 3 times the amount that the company would have made but for the introduction of the generic drug.
Which raises the big question here. If the Supreme Court rules against Hikma and opens the door to lots of induced infringement cases, would generic companies keep trying to use skinny labels at all? Or would they decide it's just not worth the risk? And if they decide it's not worth the risk and instead wait for all the patents to expire, does that mean we have to wait longer for generics? A 2019 study estimated that skinny labels came out an average of 3 years earlier than generics that came out after all of the patents have expired. And as Sarah points out, that's just the average, not the limit.
In some situations, it could save you 10 years. You could be getting a product 10 years earlier than you would have gotten it if you had otherwise waited until the product was off patent to come to market.
And Sarah is not the only one worried about that. In 2024, the FDA warned Congress that the GSK decision, that earlier case that set the stage for this fight, could, quote, significantly impact the timely availability of generic drugs. And there's already some data from a very small study suggesting generic companies are pulling back. Before the GSK ruling in 2021, about 43% of eligible drugs came to market with a skinny label. By 2023, researchers from Harvard found that only 1 out of 5 eligible drugs did so. Sarah thinks that trend is the result of uncertainty after the GSK decision, and that Hikma versus Amarin, no matter how the court rules, will clear away some of that confusion.
I think that this case in particular is really important for generic companies to know so they can have certainty about what they're doing and saying.
And if the Supreme Court rules in Amarin's favor, Sean, too, worries that brand companies will get more creative about blocking skinny label competition by filing more patents on how the drug is used, patents that are so similar to each other that it's almost impossible to write a label for just one of them.
In the Amarin v. Hikma case, the actual indication is really bad heart disease, and then slightly bad heart disease. And then I got patents on preventing heart disease. That's the kind of games that I think are going to kind of happen in the future.
Oral arguments are Wednesday, April 29th. We'll be listening. And you know who else will be listening? Dr. Gupta, the hospital resident we met at the very beginning of this episode. Along with his job practicing medicine, he volunteers with a group called Doctors for America. That's a group that advocates for access to affordable healthcare, including drugs. And he's hoping the justices understand just what's at stake for his patients.
As a doctor, when I'm sitting in front of a patient, I'm trying to figure out what's the best medication for your disease. I see the benefit of generics when they come around. I'm seeing that now, but there's still so many common medications that aren't generics yet that people struggle to afford. And if we can find a medication that you can afford, that's best, right?
Emily, thank you so much for getting us this story.
Yeah, you bet.
We'll be back with another episode in a few weeks. Till then, take care of yourself. This episode of An Arm and a Leg was produced by Emily Pisacreta with help from Claire Davenport and me, Dan Weissman. Edited by Ellen Weiss. Adam Raimunda is our audio wizard. Our music is by Dave Weiner and Blue Dot Sessions. Claire Davenport is our engagement producer. Sarah Ballama is our operations manager. Bede Bosco is our consulting director of operations. An Arm and a Leg is produced in partnership with KFF Health News. That's a national newsroom producing in-depth journalism about health issues in America and a core program at KFF, an independent source of health policy research, polling, and journalism. Zach Dyer is senior audio producer at KFF Health News. He's editorial liaison to this show. An Arm and a Leg is distributed by KUOW, Seattle's NPR news station. Thanks to the Institute for Nonprofit News for serving as our fiscal sponsor. That relationship allows us to accept tax-exempt donations. You can learn more about INN at inn.org. Finally, thank you to everybody who supports this show financially. You can join in anytime at armandalegshow.com/support. Or, for a zero-cost way to help us out, why not rate us and leave a nice review on Apple Podcasts? People read those testimonials, and it helps folks decide to give a listen. Give it a try. Thanks.